This is the different power of the legislature than power to make laws. So even this power in the present case was exercised by the parliament. Now, my lord, before I take, my lord, the last leg of my...
Otherwise, in the absence of the suspension of the proviso, what would happen was that the parliament is exercising all the powers of the legislature of the state. It would give its views on it, and it would also enact the bill.
Yes, that's the constitution.
So that's your answer to the challenge that there's duality is missing in this case, because you say when Article 356 is invoked and we have been and the proviso is suspended, there are instances in the past wherein it was this argument of duality was rejected.
Yes, my lord, I can, my lord, take directly your lordships too.
Or we'll come to that. You go in your own way.
No, otherwise, my lord, Justice H.R. Khanna's judgment on this as a Delhi High Court, my lord, in Delhi High Court is directly on the point. And explanation and my lord, the interpretation of Article 3 by a constitution bench in Mangals, that also, my lord, concerned Punjab. This very reorganization, which was under 356 and the power exercised by parliament as a legislature. But in Punjab, incidentally, even views were not taken of the parliament as a legislature, saying that the assembly is suspended. So straightway, the reorganization bill was passed. As a reorganization, my lord, this is interesting, and I'll show that judgment. What happened was, in the erstwhile state of Punjab, my lord, for example, there were 85 seats of MLAs. Now some portion goes, so 85 became 70. The remaining 15 challenged them. That how have you taken away our right to continue as members of the Legislative Assembly? And the number was lower than even minimum prescribed for any assembly to have. And then the question arose about Article 4, that you can make incidental provisions which might even amount to amending the Constitution but would not be treated as amendment of the Constitution. Constitution bench of your lordship.
Mr. Solicitor, you have referred to the fact that there is a practice, a constitutional practice, that during the operation of a proclamation under 356, the proviso to Article 3 has been suspended. And you have said that that is obviated by the reason that if you don't do so, and the legislature is only in a state of suspended animation and not dissolved, the legislature may conceivably meet to express its view. To obviate that, Parliament, the presidential proclamation does this. But none of this constitutional practice cannot obviate the legality of what is done, right?
But here, in the present case, even the views are taken, but views are given by the Parliament as a legislation. In Punjab, that was not the case.
So Parliament would then give the views
to itself.
And it would also enact the legislation for reorganization.
Yes, but that's the inevitable consequence.
But would that really be consistent with the federal document?
I will show that. It does not destroy federalism at all. I'll be able to satisfy your lordships. I'm just, since we are discussing this, I have not taken up the point of state reorganization.
All right, but you're saying that...
Yes, but since we were I was answering the proviso to Article 3, which came with 356, I'm reading this, Judge.
All right.
Lord, in both the cases, the views were not taken.
Possibly it takes into account sometimes there may be a breakdown of constitutional machinery within the state when the reorganization itself
is the solution. When there is a... Lord, kindly appreciate, Lord, by this, Lord. I'm sorry, not kindly, Lord, consider this. Lord, when the reason for imposition of the precedent rule is such that to bring that state out of the situation which resulted into imposition of precedence rule, maybe state requires to be reorganized. Then, my lord, the position cannot continue as it is. The President of India can take a call that the only solution of the problem is reorganization of the state. And your lordships are, my lord, the arguments repeatedly advanced was that there is a retrograde step. We were brought down from state to UT state. I will show, my lord, from the reorganization. It's a state for all purposes. It's a state with legislature, with only power of police with the president. It's a detailed state reorganization. Everything was factually wrong, that my consolidated fund has gone, my representation in parliament has gone, my election voting in president's election is gone. Specific statutory provisions are made. GST council is gone. Look, these are the arguments which were. So, I am coming to that reorganization. The UT, Lord, is essentially as much a part of federal structure as any other state in a given set of facts. My lord, your lordships have, my lord, I don't want to jumble up, my lord, my submissions, but there are, my lord, submissions. What would be the contours of your lordship's examination once your lordship finds that 356 exercise was not to be faulted with? What happens thereafter? There would be a restricted scope of judicial review. That's what Bomai has said. It's a narrow compass doctrine. No? Your lordships are aware. My lord, I'll take your lordship through them. Situations where it is necessary that for some time this remains under union as union territory. And the Honorable Home Minister on the floor of the House has said that this is a temporary measure. Ultimately, it will become a state. But that's a separate argument, but I'll come to that.
Mr. Solicitor, this may be your answer as far as Ladakh is concerned, but converting J&K into a union territory, what has been argued by the other side is downgrading.
I must meet with them.
That argument, number one. Number two is Article 356, the maximum tenure as prescribed is 3 years. We have crossed those 3 years.
At the time of, my lord, I'll answer that, my lord, but 2019 we have not. And thereafter, my lord, we are in a different regime.
No, I know. Now, as a union territory, that 356, that part will not apply because union territory is something different.
Yes, my lord. Therefore, my lord.
But if it was not a union territory, then
it would have crossed. It would have crossed by now. But for the intervention of 5th and 6th August 2019.
Yes, that's
yes. And my lord.
But Sadr Riyasat had already gone, right?
Yes.
So then what was the need for bringing this in 1966?
No, I'm sorry. Sadr Riyasat went here.
Oh, it went here. That's right.
Here.
Earlier, the amendment was Sadr Riyasat acting on the advice of the Council of Ministers. Earlier, it was individual capacity. Then it became acting on the advice of Council of Ministers. Here now, the Sadr Riyasat is replaced by Governor.
Governor acting on the aid advice. Yes.
But the fact, however, remains that insofar as J&K is concerned, J&K bucked that trend. J&K went to the 370 route.
Oh. Yes, my lord. But why, how, and till what time?
Right.
That will come, my lord, subsequent.
Right.
And that's why, my lord, for me, as I said, my lord, in the outset, connecting the dots would be necessary.
The instruments of accession of various princely states contain certain reservations. Now we have seen in regard to taxation, in regard to land acquisition,
binding constitution.
Not binding themselves to accepting a future constitution. So the IOAs at that point of these states were hedged with various conditions.
This is also.
But that was consistent with Section 6 of the Government of India Act, which was adopted by Section 9 of the Indian Independence Act. We gave this sop to the princely rulers that, look, you come here on your terms. We are not telling you today to come on our terms. You agree to the Indian Union, you make reservations, and we hope that by and by you will accept full integration into the Union, which they did.
There was an argument that instrument of merger was a necessary attribute for a complete integration. Otherwise, we had kind of an internal sovereignty. Your lordships would recall that Jammu and Kashmir never signed instrument of merger. Many states did not sign instrument of merger. From the date on which Constitution of India came into force and Article 1 came into force as an act of the state, they became integral part of Union of India. And how Jammu and Kashmir got separated, my lord, and how it was only for a temporary period, would succinctly come in subsequent.
Interesting, Mr. Solicitor, this Department of States which existed in the Ministry of Home Affairs post 1950, after the 7th Amendment, right? 1956.
238 was, yes.
So the Department of States must have been abolished post 1956. You will be still having records in the Ministry of Home Affairs?
I'm sorry, my lord, my instructions are Officer sitting, my lord, was the additional secretary in charge of Jammu Kashmir in MHA. He said that department technically still continues.
So Department of State still continues.
Still continues.
Now, do we have, I'm not sure whether this exercise can be done just for, you don't have to do it by a very detailed document, but just a tabulation. If we can have a list of the states and, we can have, say, Kathiawad, instrument of accession, supplementary instrument of accession, and merger agreement. Which of the states came into the union with a merger agreement? Which of the states had no merger agreement at all and yet joined the union? I don't know whether that now at this point of time that record will be there. If you can try and record, if you can sort of.
Yeah. To a large extent, white paper indicates what happened.
I don't know if you have that record. I mean, how many out of these 562 who actually joined the Union of India actually executed merger agreements?
What happened?
What I meant was, how many of these states which joined the Union of India did not execute merger agreements? That will be a smaller group probably.
But possibly.
So, which will then perhaps give some support to your argument that the execution of a merger agreement was not quintessential to acceptance of ultimate sovereignty by India. And second, many states, many princely states were subsumed with the Union of India even without a merger agreement. And various states, therefore, were subsumed in the Union of India only with an instrument of accession.
We'll do that exercise. Substantially, everything is there in the white paper. But if there is something else also,
all 562 states, not India. What happened? No, there were small little principalities, small nawabs. They were larger.
We were just, in fact, Brother Suryakant was giving us a little bit of backdrop about Punjab and Himachal.
To integration with larger states. And then the larger one signed the instrument of merger.
Right. But we were wondering, was it possible? Because, Mr. Sibal, what we want a little bit of just factual.
I have understood.
Factual clarity. That they may have, were there Indian states, we shouldn't call them princely states. Because as Mr. Sibal says, some of the small Nawab, some the princes.
We will have to say princely states, because Indian state would mean those which
governor's
the sovereignty or suzerainty of
British
India. That's how it has.
They were the governor's provinces.
That's right.
No, but we just want to know this.
We will undertake.
To sort of repeat two things. Which were the states which accepted completely to be subsumed within the Union of India without merger agreements, and followed only the IOA course and straight came into the Union of India?
There is no such instance, with respect. The white paper, which is part of the record. White paper issued by Sardar Patel.
I will not formulate it. I have understood the question. Let me not.
Mr. Shankar, I just thought since the Department of States exists even today, this is something. This will be. They might take a day or 2 days, but they will be able to do it.
It would be done.
It's able here, but the states which have not entered into a merger. Helping your point. Actually, if you want a list of states which have
What is the source? What is the source of your table?
It's from the white paper.
White paper. There are inaccuracies. I'll put it that way.
So there are states which did not accept the merger and yet became a part of the Indian Union.
State of Mysore, state of Saurashtra pre-independence, Madhya Bharat, Patiala and East Punjab.
This is
part from the white paper. There is a chart.
We will not. Let's not deviate from it. I have not taken the point.
Your point is that there were other states, basically whether it was 2, 3, 4, 5, whatever. There were other states which did not sign the merger agreement.
Yes, there was nothing special which is being claimed.
That's your point.
And second, that merger was such a sine qua non, without which you can never be an integral part of India, either under Article 1 or otherwise, or your special status must continue.